If a parent does not agree with an IEP team decision or the special education services their child is receiving, or feels like the IEP is not being implemented appropriately, there are several dispute resolution options available. Part 1 discussed informal dispute resolution options, like communicating directly with school staff or DPI, facilitation, and mediation. But sometimes a parent may want to consider formal options for resolving the dispute. One formal option is to file a written complaint, also called a state complaint, with the North Carolina Department of Public Instruction's Office of Exceptional Children, also known as DPI. In the complaint, the parent or an advocate needs to describe the school or IEP team decision they disagree with and, if possible, explain how the school violated the student's special education rights. You can find the state complaint form on DPI's website. The form is relatively easy to fill out, does not require a lawyer, and includes spaces for the parent or advocate to input all the information that is needed. If DPI determines there are potential violations, they will investigate the complaint by reviewing the student's records and talking to the parent and school staff. DPI will typically only look at violations that occurred within 1 year from the date the complaint was filed. DPI will determine whether the school violated any rules and issue a written decision within 60 calendar days. The quick timeline is a great thing about the state complaint process. If DPI determines that violations did occur, it will order corrective actions that the school must do to remedy the violations. Another formal complaint option is to file a petition for a contested case hearing, also called a due process complaint, with the Office of Administrative Hearings. The complaint must be filed within 1 year of when the parent knew or should have known about the problem that is the subject of the complaint. In North Carolina, due process is litigation. It is not technically required for parents to have an attorney, but it is very difficult for parents to handle due process cases on their own. If the case does not settle and goes all the way to hearing, an administrative law judge will rule on the case in a written decision. This process can take months or even years. Unfortunately, the clock cannot be turned back. There can't be a do-over of the past school year, but there are some remedies that are available to make up for the harm that was caused. These include things like changes to the IEP, implementation of the IEP as written, compensatory education, training for school staff, changes in a district-wide policy, and payment for private school placement. Compensatory education compensates or makes up for the services the child missed because the IEP was not implemented. The compensatory education plan does not have to be decided by the IEP team. A parent can make a request for compensatory education to the Exceptional Children's Director for the school system. The parent and the EC director can work together to reach an agreement about the type and amount of services the student will receive. The services must be provided outside of the regular school day, such as after school or during summer vacation or other school breaks. The services should be provided by a certified teacher with the same qualifications as required by the IEP. The number of hours of compensatory services may be fewer than the total number of hours of instruction missed if the compensatory services are provided at a lower student-to-teacher ratio. Reimbursement for private school placement can usually only be ordered through due process. The judge can award reimbursement for money spent on private school tuition or tutoring if the parent can prove the school did not provide the child a free, appropriate public education or FAPE. Other than reimbursement money, a judge cannot award money damages to the parent or child because the law governing special education does not allow for money damages.